say that this was a deliberate choice to include ADR as part of the discussions with regard to the Constitution, because we hardly discuss about the role and the importance of ADR. Yet, in this new dispensation under the Constitution, ADR has played a very pivotal and important role in shaping access to justice. And I am very confident that these eminent panelists that we have today are going to do justice to this topic. So it gives me great honor to introduce the panelists today, though I will leave to our moderators to expound further. First of all, Ms. Njeri Kariuki, who was also one of my mentors, and I've sat under her in some of her arbitrations. Thank you, Njeri Kariuki, for joining. Mr. Matthew Nyabena, the chairperson of the LSK Coast Branch. Ms. Eunice Lomalas. Ms. Caroline Kamende, she will try to join us a bit later, our vice president. She's been held up at Makueni Courts. Ms. Makena Okiro. Ms. Jacqueline Wahenya, who I had the honor of sitting with at FIDA board, and Ms. Victoria Keegan. Thank you very much for giving us your time during this important event. And I want to hand back to our moderators for today. We'll have Council Member Riziki Emukule. Thank you, Riziki, for joining in all the way from the coast. And we will have Gishohi, who is stepping in for Caroline Mudeu. Thank you very much, and Gishohi, I hand over the battle to you.
Thank you so much, Faith. Indeed, this last panel of the day, we'll be discussing the gains of alternative dispute resolution and the new frontiers under the Constitution of Kenya, 2010. I'm told not to say the new constitution any longer. It's 10 years old by now. I'm not sure whether it enjoyed its 10th birthday, but we can have a look at that in a bit. For about now, we want to welcome Council Member Riziki Emukule to introduce to us our panelists for today. If Riziki, you can hear me? Can you carry on? Thank you so much, Riziki, for making time to even join us well on transit. And of course, to begin our conversation this afternoon, being the last panel, we begin our conversation on the premise of Article 159.2 of the Constitution of Kenya 2010. And I read it verbatim. The Constitution says that in exercising judicial authority, the courts and tribunals shall be guided by the following principles. Justice shall be done to all irrespective of status. Justice shall not be delayed. Alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms, shall be promoted subject to Clause 3. Justice shall be administered without undue regard to procedural technicalities, and the purpose and the principles of this Constitution shall be protected and promoted. Of course, this is the premise of our conversation this afternoon, and we want to look at how we have come through as a nation and as the legal space in terms of arbitration and alternative dispute resolution and the forms therein, as well as new frontiers under the Constitution of Kenya 2010. So to my panelists, my first question would go, I'd want to begin with Jerry Karaoke, who I believe is the senior most, if you could hear me. And my question would be for you to, in about 5 minutes or less, walk us through the journey prior to the 2010 Constitution in regards to alternative dispute resolution. If you could hear me, Jerry Karaoke. Seems like we can't hear you, senior. A minute. Okay, fine, senior. As we get to sort out the technicality on the sound, maybe we can have the same question answered by Senior Jacqueline Oihenya. And the question I'm asking is simply the journey that we have taken as a country prior to the 2010 Constitution in regards to ADR.
Okay, thank you for this opportunity and thank you for the question. ADR found its way into the Constitution in 2010. I'm not so sure I can speak to before 2010 because, as you can see, I'm a fairly young practitioner. However, this is what I can say. When we think about ADR and including it in the Constitution, we look at it as though it is something that is very new. That is not true. We have had ADR systems or mechanisms applicable in our communities from way back when, as far as antiquity. So we cannot really go back into that far back into history. But the truth is, even if you look at our communities, we organized ourselves around elders who would engage in what we are now calling alternative dispute resolution mechanisms or methods, and that is how they manage their communities. And moving on into the development of the country, of course, we've had the impact, first, of the interlude of colonialism. And the colonialists had a different way of doing things, which was now to enforce law or rules mostly to impact on the imperialist interests. And once the colonialists were out of the picture, we got our first constitution. I think some of us call it the Majimbo Constitution. And once it came into play, we were able to now get into independence and have what we call our self-rule. What we can say about how it impacts on constitutionalism and ADR is that the executive was fairly took control of that particular document, and by the time we had the new struggle for democracy, the 3 decades, we were able to find that the call for alternative dispute resolution was required, mostly because as a response to the feeling or the consideration or the perception that the judiciary at that point in time was the handmaiden of the executive. So it was very informed on providing a new channel for the dispensation or the access to justice. So when the discussions for access to justice came into play, then also as a practical measure and also following the South African Constitution and the US Constitution, but mostly South African Constitution, which already had put in what they call the democracy constitution, the provision, I think it's Article 34 of the South African Constitution, which provides for alternative dispute resolution. So because of the failings or the perceived failings then before the new constitution, we found that ADR was included to bolster the judicial authority. And it's actually no accident that it found its way into the particular article in the Constitution that talks about how judicial authority is to be carried out.
Thank you so much, Senior. And perhaps for us to break that further down, I want to ask Ms. Eunice Lumalas. I must say that the first time I ever met her, I'm not sure she remembers, we were discussing again ADR, and I was very, very impressed, and I went back asking who was that and what does she do. So perhaps you could break for us Article 159.2 in a language understood by members of the public, because I see on our live that not only are advocates listening in, but also members of the public. They would want to know what exactly is in the writing of Article 159.2, Eunice.
Thank you very much. I would start by saying very clearly that we have to understand that prior to 2010, our laws and even the Constitution, 2010, was not made for the native, okay? So laws and the judicial system was a foreign system not made with us in mind. And when you're talking about alternative dispute resolution, focus on the resolution bit, because alternative dispute resolution would take you to and appeals to the humaneness of people in resolving disputes. It is more in touch as opposed to the courts, whose job is to enforce the law and to look at rights, okay? So ADR is a process that is focused on appealing to our humane nature, you know, in trying to get to the resolution of disputes. If there is anything anyone must remember from this conference, is Article 159 of the Constitution. So that is the article that has acknowledged, one, that it is estimated that over 90% of the people of Kenya don't come to our courts. And therefore, we want to tell them that wherever it is they are having their disputes resolved, because disputes are part of us, that process is still legitimate. And that's why Article 159 is there. It is there to give voice to Article 48, which provides that the state, the government, ought to ensure that each Kenyan has access to justice. And if you're saying only about 10% of the people of Kenya come to our courts, then disputes are out there being resolved somewhere. So Article 159 is there to help courts to change its thinking in terms of dispute resolution, allow courts to be able to support the processes out there that are happening, and to encourage, if they receive an enforcement agreement arising out of a mediation, they must not frown upon it. They will embrace it. Or coming from either mediation or conciliation or any other process out there, they should embrace and enforce if that's what they're supposed to do. So courts are opening up their doors to resolution of disputes outside the courts through that article. It's also supposed to give impetus to many more Kenyans out there to know that disputes can be resolved in a faster and cheaper way. So when you look at the wording of 159.2c, it allows courts not to overemphasize technicality. Because in courts, when you go to courts, if you're not able to learn or know about civil procedure or the rules, or you have not learned Latin words, legal words, then you can get lost there. So the article asks courts not to emphasize on technicality and to acknowledge other ADR processes out there. So I think, in general, members of the public are aware that courts are there to support them to resolve their disputes out there in any other way. So I hope that's...
Thank you so much. Thank you so much, Senior Lumaras. I see the people here clapping. I don't know, maybe that was good. There's something that Senior Wihenya mentioned, and she said that prior to the 2010 Constitution, the courts were more or less an arm of the executive, for lack of a better way to put it in. And I want to welcome Ms. Victoria Keegan, who sits at the Nairobi Center for International Arbitration. And I want to hear what's her view about that and what exactly they do at NCIA and whether that still would fall under what Senior Waihenya was clustering as under the executive. Carry on.
Thank you very much. I hope you can hear me. That's a very good pointer that Ms. Waihenya has mentioned, that the courts fall under the executive. But let me just give you a brief overview of what we do at the Nairobi Center for International Arbitration. Just a backdrop to it, right? In 2013, the Nairobi Center for International Arbitration was formed by an act of parliament, the Nairobi Center for International Arbitration Act. Now, it took some time now for the NCIA to probably establish its own footing in Kenya. And in 2015, December, we came up with our rules, arbitration and mediation rules. Now, that would mean that despite the fact that we are under the arm of the government, as you would say, we are an independent institution. We have been able to receive our first case in 2016, an arbitration case. And from that time, up to now, we actually registered our 50th case with a caseload value of about 12.9 billion Kenya shillings. Now, when you talk about independence, I must mention that in our panel, we have a panel of independent arbitrators and mediators who are, you just don't walk into NCIA and then you're given that because you're saying, oh, I'm from this arm of government. You have to be specialized. You have to have had experience. And I can recognize Ms. Lumales here. She's in our panel. And she had to submit her application, which went through two-prong test. It has to be submitted to a committee, which reviews her application critically, and then it goes to the board of directors, which reviews the same application, and it is approved, and that's when someone is appointed to our panel. Now, apart from being appointed independently, there's also the aspect of dispute resolution. When parties present their cases to us, we do not take it upon ourselves to now appoint the arbitrator. It's mostly on party autonomy. The parties have the right to appoint their arbitrators or mediators or any other kind of ADR practitioner. Now, this means that if at all at the end of the day the parties are not agreeing, that is when we come in. We are facilitative. We give administrative services. That is one way to show that we are independent. And once, upon this appointment, the arbitrator has the right to conclude the case without us interfering. Despite the fact that we have case counsels appointed to the case, it's for us to make sure that the process is seamless and the parties, the timelines for the arbitration is completed in that particular timeline. So there's really no aspect of executive overload or executive interference at the Nairobi Center for International Arbitration.
Thank you so very much. I hope that was well understood. We will be coming back to you much later. I'd want to hear what Ms. McKenna has to say for us. I believe she sat at the Chartered Institute of Arbitrators Kenya, and we wanted to see what exactly does it mean now marrying what Senior Rumales has put and what Ms. Victoria has put. We'd like to hear from McKenna. What in your view is the simple most way to get a matter referred to arbitration or ADR or any form of dispute resolution that is understood by a general member of the public? Because often than not, when it comes to taking matters to court, it's rather straightforward. Yeah? We just file our pleadings, we take them to court, and they are placed before whatever judicial officer, and we have the matters given their adjudication. So we'd want to hear from you. One, speaking in as a young member of the CIAB, and we'd want to hear how that has worked and how you have, if any way, married with NCIA, and do you still believe that NCIA is not under the executive? Carry on, McKenna.
Wow, that was a loaded question. So I'll try it. I hope you can hear me.
in a contract, there could be a provision for mediation, and so you go to mediation based on the contractual provision such that it says that if a dispute arises, you go to mediation. 3, this is around now these issues of, I'm sure most of the public who are maybe logged in or are interested in courts and this legal awareness week are more interested in mediation if they have court matters. Now, when matters go to filed in court nowadays, there's what is called the court annexed mediation program. I don't know whether you will explore it later, but I'll just say this. Matters are screened by the registrars before they can be decided, before it can be decided whether they go to mediation or they go before a judge. Now, all family and children matters are screened at the point of filing. Commercial matters are screened, but not, I don't think it's at the same volume as family matters. Now, once your matter has been screened for mediation, the court registrar, that is the registrar in charge of mediation in whichever high court that you're in, will refer the matter to mediation. A mediator will be picked from the judiciary list of accredited mediators. The judiciary list of accredited mediators is accredited and the list is online, and that mediator is not going to be paid by the parties. It is the judiciary that pays for that mediator. Further, it is not just that you wait for your matter to be referred to mediation. Nowadays, if you file a matter in court or you have a matter that has been in court for long and you would want to explore mediation, you could approach the other parties so that a mediator is appointed in the interim so that you attempt court annexed mediation. It doesn't mean that you must settle. You can just try it for the sake of seeing whether you will settle, and then after that the matter will be removed from court. The advantage of court annexed mediation in Kenya is that once you reach an agreement, that agreement will be recognized as an order of the court. You don't have to also start looking at issues of certifying it as compared to mediation that is not court annexed. On the issue of NCIA, I'd like to say that the Nairobi Center for International Arbitration, pursuant to the 2020 Arbitration in Africa survey, was listed amongst the top 5 institutions in Africa. As such, for an arbitral institution, because this was a survey where there were 350 respondents, for an arbitration institution to get to be top 5 in Africa, a continent which has close to 100 arbitral institutions, it means that it has some qualities that are desirable. One of the qualities is lack of interference agencies because have interacted with the NCIA, and as the NCIA is an independent institution, that is why it was number top 5. Also in terms of how their panel arbitrators and mediators, their panel is independent and also domestic and international. For people to apply to be on that panel, they not apply to a panel where they know there's interference. So in terms of independence and vouch for the NCIA, was not just we are not just vouching for it because we are local users being Kenyans. It's also been recognized internationally and regionally. Lastly, on the question of Chartered Institute of Arbitrators, that question was ambiguous, so perhaps you want to maybe clarify it or narrow it down.
I want to narrow it down, but also add a few more, one more last one that you can take as well as you take that. It seems to us that you might be among the arbitrators and the practitioners here, you might be the youngest, and there's a general feeling that the ADR is a reserve for older people, is a reserve for older practitioners, and considering that the majority of the arbitrators and those taking up ADR are actually lawyers, what would you want to say into that? And my question to CIAB was how the journey has been as CIAB, as a young leader. You were a leader there, should be last year, and maybe that can be taken together. Thank you.
Okay, let me be showing now. Regarding the Chartered Institute of Arbitrators, I'd like to say that anyone interested in arbitration, that should be your first port of call in this jurisdiction, because you have the advantage of meeting a bigger community of people, and the training there is still world class. Even when you compare, I mean, it is a branch of CIAB London, and the curriculum is worldwide recognized, and CIAB Kenya has qualified tutors. So that anyone intending to get into arbitration, that is actually
That is well noted. We will be sure to give you a few questions. We want to give one to Senior Njeri Karaoke. I want to believe that you were first a litigator before you ended up being an arbitrator. What informed that single decision, and how does it marry now that you do both? I believe so. And I had asked you an earlier question, though it was taken by Senior Jacqueline, so I would want to ask you now, you take us through the journey, how has it been, and what is that one major challenge that you would say is facing ADR uptake in the country as well as implementation?
Thank you very much, Mr. Bishoki, for the opportunity and for the questions that you posed to me. First, let me be clear, I was not an prior to arbitration, and in fact, probably what informed my decision to walk into the halls of arbitration, because I'm more comfortable on the side of the desk where a decision has to be made. So my journey started in 1992. That's the time I went to the entry course. Arbitration had been around in Kenya since about 1982, when the Chartered Institute, the Kenya branch, was started here. Yes, I've heard last message something about youth and age. At that point in time, yes, it had to be an old person. When I first started, you couldn't even get to fellowship if you were not 35 years old. Couldn't even start, but you could do you could start with the course, but you were not 35, there was no way you were going to be a fellow. So yes, it has been a journey, and first of all came general acceptance in the society with arbitration, even as of I think the first time I came across arbitration was in 1995. So 1992, the uptake was starting, but more so with other professionals. Lawyers did not take up arbitration until much, much later. The other professionals in the constructory, the QSs, the architects, the engineers were more involved in arbitration. In fact, my teachers, it was not lawyers. I would say that lawyers started the uptake probably long after 1992, and probably even into the 2000s. That the more prominent lawyers were picking it up, but not even the people who were most prominent even at that time were still not interested in working in arbitration. As for mediation started, my first course in mediation was year 2000, and still it was an alien thing. This is in terms of structured mediation, because I've heard Jackie say, of course, mediation has existed for a very long time within the Kenyan Review, and it is the case, because I mean, how otherwise have we sorted out our disputes for centuries? And in fact, I think, I would not even say it is mediation, I think it was more arbitration. If you think about, what do you call them, entities such as the jury chamber, I believe that they impose procedures, they do not mediate. So it is more arbitration, I think, that was around for a longer time, rather than mediation. But mediation, to some extent, within maybe in the home, where the conflicts between husband and wife, of course you get a mediator. One person, not necessarily well schooled in the area, but something will help you resolve your problems. So for the journey in terms of structured mediation and arbitration, the uptake for arbitration within the courts has been faster than mediation. Even as of 2005, we were still having problems as far as mediation was concerned, but with the Constitution in 2010 and that exhortation to the courts, we've heard Eunice say something about the courts these ADRs and arbitration have a role to play in reducing the disputes within society. I think it's Eunice I heard her say something about arbitration in ADR. I can't just right now recall exactly what it was. Things which end, training lawyers, typically lawyers before this nonsense you're following through on. What is this funny little thing that you're dealing with in terms of what is it? But in 2010, it became like it's just the holy grail, and lawyers saw that this is a place to live, to find your way to it. So arbitration has gained a lot of credence in the last 15 years, and even through the courts, it's become the courts have become more interested to the idea of arbitration. And with this latest Bottlenecks litigation, and it's a whole paper, it is accepted across the board now. And I have to say, in 2020, mediations in contracts, people agreeing to do mediation through the contracts and through court. It has gained a lot of acceptance. That was very short.
Thank you. Thank you so much, Senior, for that.
I hope I answered your questions.
Yes, you did. Please hold on there. We will be getting back to you much later. We are joined by our chair from Coast Branch, Mr. Matthew Nyambena, and I see should be Miss Eunice Lumalas, and I think also Jackie and Jerry Karaoke. You're talking about the way we used to settle our disputes way before all these adjudication and court procedures started. And Chair, you come from an area known to have Wazee Wakaya and the dispute resolution systems around that area. And I know when I talk about elders of the community, such a time as this, it's very contentious. Again, I don't want to go into the nitty-gritty of who becomes an elder and why. But I want to hear from your experience. How is the uptake of ADR at the coast? And how do you think this could be getting better thanks to the Constitution of Kenya 2010, Chair?
Starting from the elders, we realized that most Kenyans actually fear their traditional dispute resolution mechanisms. Traditional odds are very feared. I was in a seminar the other day where Professor Kibwana said if you have the Kamba office system to solve some of these disputes, some people will quickly confess. So really there was that kind of system which has been recognized, and I look at it at the alternative justice system, even including criminal systems where communities could be able to solve their disputes without resort to enforcing what I call a code of flesh. I look at, in fact, reminding myself of the book Merchant of Venice, I look at Shylock, the dispute between Shylock and Antonio, and how Shylock represented the radical person who said that I want my pound of flesh, I want my day in court, and now finally he ends up losing everything. So I want to see this as an alternative justice system, as a way of sustaining relationships. People are having disputes in court, come to court because they are a relationship that has failed. So the intention of resolving this matter through the alternative justice system, which invariably should end up in a handshake, is to sustain this relationship so that people can be able to go forward. The uptake of alternative justice system in this country and this region has been very well. I can record for myself that we have had disputes that have been long-standing in court. In fact, it's very useful in land disputes within the coast, which are very many cases of maybe people have stayed in somebody's land, they are trying to be evicted. If you go the court way, it's either going to be an eviction, or if there is no eviction, then the owner of the land is going to lose that land. So we have had situations where, as by virtue of this alternative justice system, by way of mediation, parties are able to mediate and say this is how we're going to sort out this matter. So this has been quite helpful. And also in the criminal justice system, maybe this has not been talked about so much. We've had idea of plea bargaining, we have had people reading conciliation, we have had diversion. So we do not need a system where you say, I want somebody in prison. You want some form of justice without the necessity of somebody going to prison. And this helps in the manner in which we do not then have to congest our court system. And maybe there's also a perspective that has not explored is the spiritual perspective. The spiritual perspective, when the Bible says before you have a dispute with your colleague, try to sort it out before you go to court. So if we also refer these matters to spiritual leaders, they be able to solve some of the disputes that we have, so that we are then able to reduce the backlog in court. And in any event, after you file that case, court is stuck there for 2-3 years, all that it requires is for somebody to tell you that we can talk. And talking as a proved quite in this manner. We need to strengthen it. We need to educate people on what letting people live in unity, because court judgments can be very, very harsh. And at times, I dare say here that court judgments do not necessarily deliver justice, because they deliver you the verdict in accordance with the law, which may not be fair and just to all those who are concerned. Thank you.
Thank you so much, Chair. Thank you so much, Chair. Ms. Eunice, there is something that Senior Jerry Kariuki mentioned, and I also think it had been mentioned by someone else, that there was a point in time when, as lawyers, as advocates, had not yet accepted ADR fully into a system. And I remember there has been serious contention as to whether we have a center for arbitration in Kenya. We're not going into the details right now, but I want you to talk about a little bit about when did we see the light and how far have we come with seeing the light in uptake of ADR for us as practitioners, senior.
How I would answer that? I would still trace it back to 2010 and the constitution that we have now. When you look at 159 2C, it talks about embracing, acknowledging, and taking stock of other methods of resolving dispute, and actually allowing them under the Kenyan constitution. So you have mediation. Now we can do mediation as a country. Lawyers have to acknowledge mediation is there by law. Arbitration is there. And importantly, traditional dispute resolution mechanisms. You've heard Mr. Nyaberi talk about how severe, how scared people were of the outcome. I mean, if you've been told you will be cast, or you have to take a certain oath, the oathing, by elders, particularly at the Kambas have a very good system. People get really scared of the outcome. So that helps people to negotiate and to resolve disputes entirely. Now, is it true that the lawyers have been slow in the uptake of ADR? I do not think so. A lot of work has gone into changing the mindset, okay? I want to applaud the Chartered Institute and the Judicial Training Institute for the many trainings undertaken to judicial officers to help sensitize them on ADR. And I want to also laud Law Society of Kenya, the successive leadership of Law Society of Kenya in taking steps through the continuing education committee in sensitizing more and more lawyers to take up ADR. So there are, and I think there was a time where there was ADR, a component of ADR in every CPD. So all this goes towards helping change minds of advocates about resolving disputes through mediation and other methods. Even in terms of income, the more matters you resolve and get out of your way, the more you are able to get more business and move forward. And I think lawyers are getting to understand more and more how to bill when it comes to mediation. So it's a journey, and I think the judiciary with the court-annexed, court-mandated, court-annexed mediation project that started in 2016 April, that has in itself really opened the eyes of many lawyers to taking up mediation, because somehow it's been mandated in certain cases. And when you look at our civil procedure rules, when you look at our Civil Procedure Act, Part 4 thereof, among others, you find that even if you have a case in court, right now you're allowed to refer that dispute to mediation or to other ADR processes, even when they're in court. So we have the court annex mediation system that comes with the mediation accreditation committee that has been mentioned earlier, and more we are going to see more and more people opening their hearts, opening their doors, opening their practices to ADR. And so therefore we have seen the light after 2010.
May we continue seeing the light. I'm reading into the judgment delivered by Judge George Dulu, and this is for you, Ms. Jackie Wihenya, in 2017, 5th of October. It's criminal case number 2 of 2016, Republic versus Musili Ivia and Mutinda Muli, who is the second accused. In the judgment, the last line, the judge said that he's not aware of any written law or international convention that prohibits the amicable settlement proposed. And he further says that the victim is already dead and the close relatives agree to the settlement. I have not been told that there is any objection from the community or the public. I will therefore accord the clan settlement consideration in this matter. In this matter, it's a well-known case whereby the court allowed that arbitration and ADR rather can be taken up even in criminal proceedings. And I have heard Ms. Eunice Lumala's talk about how the same has been incorporated into our civil procedure rules. The first question to you, Ms. Jackie Wehaya, do you think it's time that we amended our criminal procedure rules to include ADR as a form of practice and have it in statutes as so? Number 2, how do you like the uptake of ADR into criminal proceedings? Carry on, Jackie.
Okay, thank you very much. I think when we talk about ADR outside of what we are now thinking about as the traditional traditional areas or the traditional mechanisms of arbitration and mediation and conciliation, but usually we think about it within the context of commercial law because our initial uptake was within the commercial sector. And if you look at not only Justice Dulu's decision, but various decisions that have been made since we promulgated the Constitution have been in favor of adopting ADR, not only within that narrow prism of commercial law. And the space continues to expand because we find that in any dispute where the parties agree, it is always superior to what a third person would come and impose upon those particular parties. The challenge with the criminal law, because it is a challenge, it's a sort of a double-edged sword, is that when we have a criminal act and it's the offense and a party is taken to court, we always presume that the republic always takes over because it's a matter of public interest. We cannot just wish away the murder of a person. And I think one of the challenges that have been seen in many of these criminal matters is, very well, you may come up with, because there were traditional methods of also dealing with criminal matters before, you come and pay a camel or two, and we will resolve this issue and we will continue living in the community together. The challenge that comes with endorsing that particular position is this. Do we put in our laws something that would be perceived or construed to be a nod to activities that are contrary to public interest, contrary also to other rights that have been enshrined in the Constitution, in this particular case, the right to life? How do we deal with this? It is not correct to say that we don't have a policy, we don't have a provision for what was described in Justice Dulu's case, because soon after then we had the plea bargaining provisions that were incorporated into the Criminal Procedure Code. The challenge that has also been seen with actualizing them is first that there is no policy framework for when do we apply plea bargaining. Is it applicable to capital offenses? Is it applicable to serious offenses? Or are we going to just deal with it where we're just having the offenses that are maybe criminal in nature but are blue collar, white collar? So where do we draw the line? Where do we begin? Are we going to allow it to happen, say, for instance, when we have terrorist matters? in court, which also expose us, because if you let people off on because they can agree, then you might be returning the same element to perpetuate another criminal offense. So I believe that the best way to deal with this particular development is to come up with a policy framework for it, figure out when we can use it and utilize it, and also think about who should be able to access it, how it should be done, because when the plea bargaining provisions were put in place, some people also tried to enforce an agreement without involving the Office of the Director of Public Prosecutions. And what the court has found in those particular situations is that you need to ensure that the DPP is part and parcel of the agreement that is being made, and that it is not contrary to public policy. So that is a difficult question to answer. In relation to criminal offenses, I believe that we need to sit down and ask ourselves, okay, plea bargaining is actually ADR. When are we going to be able to use it and utilize it? And then ask ourselves, we are seeing the space for ADR grow from where we started off in 2010, where we were thinking, okay, let's enable arbitration, and mostly within the commercial sector. But we are finding that in addition to the commercial aspect of it, particularly from I think it's the Ismaili community, which also have arbitration provisions for personal law. So if the members who profess a particular faith which allows for either arbitration or more likely mediation for situations in which is also, the similarity is in our laws we cannot have, the two parties cannot consent to a divorce. They have to go through the formal system and get a declaration from court. But if two people who profess the same faith and there are provisions for arbitration in such a dispute, and they do get an arbitral decision, can it be enforced? Also that there is no policy framework for such particular, for such arbitrations. So I think where we need to move forward as a country is, we already have the provision of Article 159. It is there, it is in our constitution. It has created for us the bedrock on which we can grow ADR. In fact, we shouldn't be calling it alternative dispute resolution. We should be calling it appropriate dispute resolution. So that if, depending on the particular circumstances, we will know which one will be applicable. Because, like I'm sure Eunice will tell you, or Jerry was my teacher, she will tell you, what is appropriate for arbitration may not necessarily be appropriate for mediation, may not necessarily be appropriate for conciliation. And conciliation is another area, because that is mostly done by experts in labor law also. We don't also have a full policy framework for that. So I think my call, or what we should be taking on right now, is thinking about how we should have an all-encompassing policy that makes provision for all these mechanisms and make sure that they are adopted or applied in the most appropriate way possible.
Thank you so much. It looks like I was seeing Victoria nod. Sorry?
I'd like to add something that I said.
Go on, McKenna.
Can you hear me?
Yes, we can.
I think there is has to be made in terms of ADR. Article 159 mentions traditional dispute resolution mechanisms, mediation and all that. But then there are two things. There's the alternative dispute resolution. Here it is defined into arbitration, mediation, conciliation. So now, in August, I think the Chief Justice has actually launched an alternative justice system policy, HAS policy. It's a baseline survey that has had, the task force has started, I think, for 2 or 3 years. And they've come up with a policy that will now inform issues outside arbitration and mediation. What we are saying is these issues of clan elders, village elders, customary law. And so there's a policy now. The work of Bishop is thinking around coming up with regulations, the same way the Chief Justice, the former Chief Justice, came up with regulations for practice direction of the work for bottlenecks and mediation. But the policy now is there, the alternative justice system. So it's up to the Chief Justice now to distinguish which matters fall within that or not. So there has to be a distinction between alternative dispute resolution in Kenya Arbitration is arbitration, mediation is mediation, and the mainstream ADR is mainstream ADR. But there's alternative systems, plastic systems policy. That's all I needed to distinguish so that we don't miss the problem.
Thank you so much. In fact, that's where I wanted to pick it up from and ask Victoria, who seems to have not agreed fully with what Ms. Jackie was saying. And I also see Ogada is trying to nod as though he wants to throw stones. Not today, Ogada. But the question I want to ask, it appears to me that the model of the arbitration rules was initially under the United Nations Commission on International Trade Law. And I want to believe that that's where we premise most of our laws. In fact, we check on our laws and we borrow greatly on laws that have already been written, especially for the United Nations. And so when you were coming up with the rules that you talked about, Ms. Victoria, in 2015, my question is, did you ever anticipate that we would ever need to have courts like criminal matters? And what was your initial thought about the AJS as launched by the Chief Justice? And what would you have to say about what Ms. Jackie Oihenya has said? Because I could see you nod in disagreement, kindly.
I actually didn't nod in disagreement. I was actually saying, yeah, that's actually the truth. And I was nodding in agreement to the need to form policies on ADR. So that was my perspective. So let me talk about our rules. So our rules were enacted in December of 2015, modeling it from the UNCITRAL model law, as you've said it in the long format. So our rules, pretty much, we are guided by the international standards of the practice of arbitration and aid. Okay, but pretty much the UNCITRAL model law is on arbitration. ADR, mediation is on the other aspect of it. Now, as NCIA, despite the fact that we have had our particular rules as NCIA arbitration rules, we also administer disputes under the UNCITRAL model law. So we are a designated appointing authority under UNCITRAL model law. So if a party comes to us and you say, okay, in our contract, the arbitration clause or the dispute resolution clause says that our arbitration will be governed by the UNCITRAL model law, and can you please appoint an arbitrator on our behalf? Or can you appoint an arbitrator and administer the whole dispute? That we can do. And if your contract says you want to administer your dispute under our rules, we can also do that. Despite the fact that despite that fact, we've seen parties come to us, they say, oh, well, we have heard about NCIA, we want our case to be administered by yourselves, but we don't have an arbitration clause that says NCIA. What do we do? So we have a model clause at the back of our rules in the second schedule that the parties can just sign up on it, submit it to ourselves, and we will administer the dispute. Now, Mercy has mentioned about the AJS, alternative justice system by the judiciary. And that's when Ms. Waihenya had mentioned something about the policy, and I wanted to mention something about the draft ADR policy that was prepared by the, assisted by the NCIA. It's one of our mandates. One of our mandates under the NCIA Act is to facilitate and coordinate the promotion and the formation of policies, laws encompassing ADR. So as the NCIA, we went ahead and saw the need of ADR policy and the need of increasing the uptake of the use of ADR. Because as we have seen, and we have been talking about it since the beginning of this discussion, that we only have the Arbitration Act. That is the only act that exists on arbitration, and also guided by the Constitution of Kenya. So NCIA with other private and public stakeholders, the judiciary, office of the AG, and assisted by the IDA law as well, we help in coming up with a validated draft ADR policy. And now we have a national steering committee that has been formed under the Office of the Attorney General. And this committee has a lot of, we have stakeholders from the LSK, from the academia. We have different representatives. You can't say it is public sector only or private sector oriented. So we are hoping that by the end of the year, we'll be having an ADR policy. And this ADR policy captures arbitration, mediation, conciliation, traditional dispute resolution mechanisms, as has been captured by Article 159 of the Constitution. So hoping that at the end of this now, once the policy is in force, then we'll be having laws that governs all these other aspects of ADR. You may want to have a look at the draft ADR policy, and this would guide on the future and the thoughts of the Kenyans, because it wasn't really a policy that was a draft policy that was just created at the office of the NCIA. Sorry, we had to go all over the country to hear the views of the practitioners who use ADR, and also the traditional ADR mechanisms that have been used in the past and to date. So we went, I remember I participated in all those forums. There was Kakamega, we went to Kakamega, we went to Nakuru, Kisumu, we even went up to Garissa. We had, I remember in Garissa we had one of the participants who's Kathy and also a traditional dispute resolver. He said, he actually captured the issue of, is it time that we use ADR in criminal matters? And there was that aspect of exchange of camels, as we have just discussed by Ms. Wahenya. So AJS is also a good mechanism that captures, so we work hand in hand with the judiciary. So when it comes to AJS, we participate in that with them. When it comes to ADR policy, we also participate on that with them. Unless I've missed another question that you had asked?
No, that's okay for now.
Okay.
And you mentioned something which looks to me a darling to Eunice, and I want to ask her about the ADR policy. The first time I met you again, we were discussing the ADR policy at some IDLO office, and I know you're really, really passionate about ADR. So even as you answer that question, I want you now to tell us whether you think that as litigation advocates, are we bottlenecks to the process of ADR? Have we really appreciated ADR fully, and what do we need to do better so that we can attain the goals and objectives of ADR as envisioned by Article 159(2)?
I appreciate your question. I hope I'm online, because I'm a trial lawyer and an ADR practitioner. So I view both I have both perspectives of a litigant and a practitioner. Now, are litigants or litigation lawyers bottlenecks to the practice of ADR? The answer is no. When you look at various studies on what are the bottlenecks to ADR, you'll hear a number of things, and very minimum concerns will come on litigation lawyers, because sometimes a litigation lawyer would have instructions to delay a process, okay? And as a counsel, you have the instructions, you don't work, you're a mouthpiece, you act as a representative of your client. What I need to say is that we have taken a lot of strides in trying to minimize the bottlenecks to ADR, some of which are include ensuring that each party is playing their roles. If we have judges understanding their roles, then we won't have the problem we are having allegedly caused by litigation counsel, which is we are having their current trend is you have lawyers going to court challenging an arbitration award, for example, or through a judicial review process. That is not found in any other law. We have already heard that the only legislation we have in terms of the ADR framework is an arbitration act. It doesn't give anyone room to appeal, and we have been seeing a lot of a proliferation of appeals being entertained by our courts, which they ought not to. So I think there's need for more sensitization. The work is not yet done in terms of our judiciary. Everybody must do their own part. Lawyers must be trained to understand how ADR works. And once they do, they will be working in support thereof. There are many other bottlenecks to AJS, lack of information. Right now we are dealing, under the pandemic scenario, lack of access to ICT. You know, those are some of the bottlenecks to ADR. And once we are able to deal with those and sensitize as many Kenyans as possible to what ADR is, I don't think we'll have a problem. By the way, there's an effort now to come up with a remuneration order for ADR. So I think that is very good news for lawyers. So lawyers are not bottlenecks. But if your instructions are to delay a process or to file application after application, depending on the circumstance, if you have a good arbitrator, they will know how to deal with that. So I think everyone must know their role in the chain of arbitration, and everything will be fine.
Thank you so much. I love the passion on which, Jerry, I was actually coming to you. I'm actually coming to you, so maybe I could give you my question so that you can take them both. My question to you would be, she has begun talking about the gaps that are there thanks to all these changes and implementation of ADR as a practice in Kenya. So perhaps even as you take your comments, you could give us your thoughts on the gaps that are there and that we need to seal, both through legislation and also through practice, for us to see to the light of day in regards to the attainment of Article 159.2, Senior.
Okay, first let me agree with my friend Eunice that a lot of sensitization, etc. is necessary as far as lawyers are concerned. However, I will not or accept that lawyers are not, to some extent, above board. I think that we as lawyers also have a duty I think that's part of we have duty to an officer of the court. Yes, we may have received instructions to delay even before the arbitration. But surely, what is our purpose? Our purpose is to bring an end to a dispute, an end to litigation. So even as we do receive our instructions to keep filing, so on and so forth, we are at the same time increasing costs. Okay, and especially in terms of arbitration. We cannot afford to keep driving up the cost. We are paid little per hour. When we're looking, we are also not paying our own. Because our purpose must be to reduce costs or to keep costs at a certain level. So yes, you want to champion as an advocate your client's position. But yes, please keep in mind that we must keep costs down. So whereas I agree with most of what Luis has said, I still believe, advocate though I am, that we can act as bottlenecks. So if our purpose is to resolve disputes for our clients, let's find the shortest way to do so. And as Jackie said earlier, let's use the appropriate type of dispute resolver, let's put it that way, in terms of many, because there's a whole range of mechanisms that can be applied. The appropriate mechanism to resolve the dispute before you know that has been presented to you by your client. So that means your level of sensitization must be very high. Do I use adjudication? Do I use arbitration? Do I use conciliation? What do I use? So I think the point is, as lawyers, it behooves us to learn what is out there so that we can complete our remit, which is resolve the client's dispute. The one thing that I have exhorted people to do over the years is think in terms of volume. All right? Don't think in terms of that fun file where you're going to keep it for 30 years and the client is never satisfied. Look in terms of volume. How many files can you turn
Adjudication, yeah.
Adjudication.
Adjudication.
Yes, construction and adjudication, we do need an act here, because otherwise what we are doing right now is that we don't have a supportive legislative framework. And I know the China Institute was working on this, and I believe that it is going through certain legislation advised us relying on contract. Mediation, as I said, perhaps what needs to happen is the actual players need to be regulated, because we have so many shady people purporting to be mediators, people purporting to be arbitrators. They have no training whatsoever. So in terms, I think that would be important, but the practice and that needs to be left alone. Getting section around the country, because one thing that needs to be considered is that the people who are trained come from very many different training schools. So do we need to standardize this training, or is it necessary to train mediators further after, for example, the Bottlenecks mediation takes you on as a trainer, as a mediator? Do you need further training? So as to get the result that the courts are looking for, which is an uptake in mediation and not imposition through Bottlenecks. Thank you.
Thank you so much. As we bring this to a close, that was really, really well done. I want to give a question to Ms. Jackie Waihenya. We had a very beautiful pop and color event that saw the launch of the court annexed mediation in Kenya. And I have heard it being referred to by Ms. McKenna, Jerry Karaoke, and I also think one of the panelists here. I wanted to speak into how do we get to do this court annexed mediation. For a member of the public unaware of the procedure, how do they get to benefit from the court annexed mediation, and how do we go about it in giving it an appraisal, a tooth comb appraisal, as well as the critics, as we have heard from our senior. But also, being a legal awareness week, I was hoping to have my panelists also volunteer pro bono to give advice onto the review of such acts as I've heard Jerry, but I leave them to that discretion. Maybe that's the one they want to say last.
Okay, thank you. Well, court annexed mediation, I think, is probably one of the most successful programs that we have had through the judiciary. It operates from the point of view of a multi-door perspective of the court, the judiciary. What does multi-door mean? Multi-door means that people, when they are approaching the judiciary, will come in and they will, the usual traditional method of filing their cases. However, because many of the cases that are preferred to court really, and this is why again I come to my appropriate dispute resolution mechanism, and in what has been found is that many of the cases that have been filed prior to taking steps to see whether the dispute could be resolvable using other methods. And this is where the court annexed mediation comes into play. Of course, there have been the questions as to just how voluntary is the mediation that emanates from the court annexed mediation or the process. But what we have seen, because the program I think now is in its 4th year running, and what has been happening is that once matters are screened, and I think Eunice also spoke to this, in the family division, there have been quite a number of matters that are screened, and in the family division, the cases that will more routinely be referred to mediators within its probate matters, succession. You have children's matters, maintenance. And what happens is that it gives the parties an opportunity to sit with a trained neutral, that's the mediator, a third party, who will enable them to talk, discuss, and facilitate the discussions, and ensure that the procedure that is now done in court is simplified. Because many times when parties go to court, they find that what they thought is going to happen, I want my day in court, is actually a lot more complex than that. And they may find that on the other side, the party that they are, or the other, that they're dealing with is able to get appropriate legal representation. And in many cases, you find that the people who are going into the dispute resolution, the traditional, may find that there is a skewed playing field for them. So mediation, first of all, gives them a first opt into a situation where they can discuss the matter. They can discuss with somebody who is familiar with how to get people to resolve their disputes. And as they are doing so, they can come up with even creative solutions, which a court might not do. The courts, the way they are structured is that one party wins. But with mediation, you find that the parties can sit and think, oh, well, and this is the analogy we use in mediation. This is the orange. We both want the orange. But one party A wants the peel, the orange peel, to make, is it the Centaur, etc. And the other one wants to make juice out of the pulp. So the two of them can come up with a creative solution that will leave them both happy in the long run, each of them getting what they want out of the whole process. Now, once they are referred to a mediator, the mediator will ask them to file their case summaries. It's usually just 1 page long compared to our plain sub, some of which go into 96 paragraphs. And each party will get an opportunity to present their case summary. They will meet the mediator. The mediator will explain to them the process, and they will tell them that this is a confidential process. Confidentiality is really, really important because it gives parties an opportunity to speak. You say, fungua roho. That's what we say in the course, and I'm sure that's what we say here as well. And once they're able to speak and speak their truth, they can now be able to pick what the interests, and the key thing here is the interests of the party as opposed to the rights and the responsibilities of the two parties. So when they pick out their interests and each one is able to agree, okay, well, if that is what you want, I can give you so long as you also allow me to have what is in my particular interest. And when you walk the parties through the process, okay, there are two usual methods mediators use. The first one is the organic process, where the parties will meet and they, you just let them just talk and speak and do their thing. And once the temperatures cool down and the issues that were preventing them from arriving at a solution are resolved, then they will now start thinking clearly and come up with a solution that works. When they have advocates in the process, the advocates are able to advise them what is legal and what is not. The mediator is not a legal advisor, and the mediator will explain that to the parties and the advocates. Now, I have found when I'm doing mediations, the advocates actually have been very useful in the whole process because we're able to speak the same language, which the parties might not be able to speak. And when in the court system and you're within certain parameters, you know that if they move forward, they might be entering into a situation which would be adverse to them. So when they have counsel, it is preferable. And I have found that advocates, the litigation lawyers, have been very useful in crafting the solutions which are well within the legal parameters. And the thing then that happens is that you need to, and the mediators, good mediators will always explain to parties, these are the potential outcomes of the mediation process. You could agree and settle the entire dispute, which is the best case scenario. You could partially agree on some of the issues, but there may be some technical legal issues that you may want to be determined by the judge or the court, in which case what has been agreed will be recorded as a consent of the parties and adopted as a judgment of the court, but then the court will say, but it will reserve its decision on one or two, not very many complex, many different items, but fairly technical issues. And then, of course, they might not agree, and that too is a possible outcome. And then the whole point of getting the people to come through is so that they can be able to appreciate the cause of the dispute. No judge will have time to find out what the cause of the dispute is. To ventilate the aspects of the disputes in a controlled manner. Some people have disagreed and they have no idea why they are disagreeing, other than they don't like the other party, or they have come too far in their disagreement to see clearly about it. And that will enable them, even when they are moving forward to have their dispute resolved, to be able to identify and clarify the issues that they're going to move forward on. Then one of the biggest advantages, and this is for administration of justice, of mediation, is this. If the parties agree, whether it is partially or completely, the mediation settlement agreement is taken as a consent of the parties, and you cannot appeal from that particular agreement. So for somebody who is looking to bring a dispute to a logical conclusion, it is probably one of the best ways to resolve a matter, and you're resolving it within, my day in court. You're resolving it within the whole process of administration of justice. And at the end of it all, you get a decision which is already a court decision that is enforced in the usual way we would enforce any judgment coming from the courtroom. So we have found that there has been a lot of uptake from advocates, and even the parties who come and they are not very familiar with the process, they find a person who is ready to give them time to appreciate the challenges and then get from where they are being challenged and they're in dispute to the point where their interests can be made in a process that is purely and completely confidential, because nothing that is discussed in a mediation can be used as evidence or can be used in any further step in any judicial proceeding. So it is a really good option that can be taken and used for a wide variety of cases, including commercial matters. I think we've also expanded to labor matters as well. And as time goes by, I'm sure that it will also go into, and land matters as well. So I'm quite sure that it will go into the various divisions that we have in the high courts.
Thank you so much. That was very, very elaborate. Matthew Nyabena, I hope you're still there. I want to give you your final question. And you happen to serve in the WIBA Committee of the Law Society of Kenya. And Senior Jacqueline has ended by talking about how mediation might also be a tool towards solving the TDS court cases on labor relations. So what do you think, in your perspective, coming from an area whereby labor relation cases are at the spike, what do you think an ADR would do better in regards to solving such kind of disputes at the coast as well as nationally? And what is the future of ADR in that perspective? Carry on, Chair.
Going back to the wiper judgment, I remember the judges of this report of Kenya saying that the current arrangement of labor disputes, as I started before, it's about a relationship. If you have an employee today, you need to maintain the current relationship because you may need that employee tomorrow, or the employee may need the same employer tomorrow. So the best cases that ought to go through APR are actually employment cases, because basically the issues are out there. Maybe it's the inability to pay. You are not able to pay the sum now and pay it in installments. So this whole scenario of APR ought to be employed in such cases as in employment. Also, Mr. Gishu, want to look at our constitution in terms of progressive rights we have in our constitution, in terms of health, in terms of housing. To take your county government or national court on those issues, it's difficult for people to give you judgment. But if the parties were able to sit down and say this is what is able to be achieved within the ADR mechanism, this can work very well in terms of mediation. One concern in terms of the whole integrity of all processes, I remember that for our government and national resources, which are both friction and action, which give back at work. It was to those concerns that at times a good system like API can be possibly which is not good for the public. So we need to domesticate all this. And as much as we speak, maybe in terms of arbitration, you cannot appeal, then that process gets ring-fenced. And abuse it can be very, very bad to these members of the public. So ADR, litigation, conciliation, and in terms of the use of the same, I want to say that lawyers, I have a remark also, maybe I need to react to it. Lawyers may not be bottlenecks. I look at mediation. Mediation is not really about the lawyer, it's about the client. So in my plan was to delay the case and bring him to the meeting. And then I don't blame the lawyers. I think the initial reaction, I speak like a practitioner. And these processes were being done. The involvement of the petitioner was not part of the ADR process. Was not reconsidered in formulating this. But as we have educated our members, personally, I've always told colleagues that if you want to go the long way, it affects even your health. Every time you have to prepare for a case, and then you have to argue whether it has to go on or it doesn't have to go on, it takes a lot of energy. So if you can get these cases sorted out in the easiest way possible, where clients own them, advocates own them, you are able to get your fee, well and good. Basically, I think in every office there's that fight which never ends. Because when you look at it, you pull it out in January, you are thinking on how do I get out of this system? So if somebody comes with ADR and you're able to close that file, I think to me well and good. So ADR is alternative justice system, ADR and the rest should be encouraged. And I think in this country, we are to move from a level of the pound of flesh, move to a level that where we need to reconcile, we need to have more handshakes, we need to have more people smiling, we do not need the pain of litigation all the way. Thank you.
Thank you so much, Chair. You have consistently mentioned the handshake. We will get to that after the panel. You can tell us a little bit more about the handshake. But now, let's have our final comments from our panelists. And the first question will go to Ms. McKenna. And I want to ask her the single most question of what do you think Kenya would employ in terms of regional practices that we need to employ locally to accommodate the best practice of ADR?
Thank you for that question. Kenya as a jurisdiction, you see the strength, what we say in quotes. I say arbitration is very university, I mean generally, just some practice to be a function to attract arbitration both internationally and for it to thrive domestically. One, of course, is the issue of awareness that the players all have to be aware and of their role in ADR. And you see, I disagree with the issue of respectfully, because humanity is my friend, on the issue of lawyers given instructions by their clients, and so they're increasing an arbitration, you can find 17 applications. You see, my understanding of your passport is an advocate of the High Court. And this is a school of thought that I ascribe to as well, alongside seniors, and also I must go to Mr. Ohada because we have discussed this at length. An advocate of the High Court is just not a litigator. You are supposed to understand the entire dispute resolution process from dispute avoidance to resolution towards. And a client comes to you, they are only resolved is I want to go to court, I want to go to court. But you as a lawyer need to have a toolbox so that you understand the entire dispute resolution spectrum from dispute avoidance of what have you been doing before this dispute escalated, has it escalated to the levels that you want to bear, and then what is the next step that it means for the arbitration and litigation. That as a lawyer, if you want to mitigate, it is also upon you to advise your clients and say arbitration is not supposed to be as complex as litigation in terms of procedural rules and maybe such things. So that's one. Installation of the legal system is there. In terms of our arbitration act, I think Kenya has a more fairly modern arbitration act. My only issue with it is on the issue of appeal, which Njeri touched on. There needs to be a direction, proper direction in terms of what is the avenue for appeal, because the avenue for appeal is the point of law, but then increasingly some judges, at least they're trying now, I see Justice Bugi and a few others have tried to steer people back the right way before you move to the arbitration. But what I'm saying is that there needs to be direction in terms of appeal, because you see, if people want to get into arbitration and if people want to come to Kenya even for international arbitration, and they want to use Kenyan law, and in terms of the arbitration act, and the fact that our courts will allow appeals of the flimsiest of resources, Kenya no one will bring their matters here. And you see the English Arbitration Act of 1996, why it makes most people pick it, and you see seats in arbitration also means the law will increase. So it's because courts in the UK from the House of Lords, there is clear direction on very, very, very limited grounds for appeal. And in Kenya, actually, appeals, I think that people do not appreciate that for you to appeal on a point of law, you have to have consented before the hearing, before the arbitration commences. So that would have just to go and open that Pandora's box. But basically, you're winning the reputation of this country as an arbitration friendly guarantee, like you see now some people are at Olesereni and others are here at home watching. There's no guarantee that we now go back when COVID-19 there are also important guidelines on how to conduct arbitration, mediation, etc. online. Of course, there's also the issue of reputation. Our arbitration practitioners have to have a very good code of ethics so that people can pick Kenyan arbitrators and choose to arbitrate in this country. So issues of reputation and also, I think, transparency and costs. The issue of costs, I would say, is a very strict. It's up to the arbitrator and also to the parties. So that's this restriction. If arbitrators can be flexible on issues of cost or see how to work around those issues by encouraging parties sometimes to go to expedited or emergency arbitration and even at state documents only. The Charter Institute of Arbitrators has published its rules effective October 2020, and all these things now are part of the new rules. What does this mean for practitioners? As a practitioner in Kenya, avoid delay, because sometimes you may want to think in terms of fees, but it's what you usually say in terms of volume. If I can finish this matter and still make my fees in what 3 months and I'm out of there, I can focus on other things. So I think cost effectiveness is something we need to look at in terms of improving this restriction and making it more attractive. I think the last thing I'd say is there needs to be an overhaul of the cultural mindset, because people are listening that arbitration is coming to interfere with the practice of litigation or whatever. I would like to say this, as I repeated, it is up to you to ensure you have the entire whatever skill set. I know people like Mr. John have practice all forms of arbitration, mediation, litigation, he sits at the tribunal, and it's actually looking more money than you is reducing you in the arbitration. So you need to expand boundaries, because practice has gone international and people are not limiting themselves to this one thing. The last thing I'll say, because this is a legal awareness in terms of Kenyan public, please understand that you have every right to walk to any court of law, even if you have a matter that you intend to file, even if your advocate has the file, even if the matter has been in court, walk and ask for the mediation registrar and ask, can I see if my matter can go to mediation? Because mediation is, as Mr. Nyabena has said, it is for the public and it is for the party himself. Your advocate has said to him, wakili wako si yeye atakufanyia mediation. Mediation unajitetea wewe kama kivyako. So usiogope kuenda kotini kuuliza file. Hii mambo ya kuachia wakili file muache. Walk to the court and ask for your file so that you see if you can go to mediation, and the advantage of mediation, you don't have to pay the mediator. Other than that, I'd like to thank the Law Society of Kenya and the council and the organizers of this panel, and also to my co-panelists for the good panel, and I wish you a good evening. Thank you.
Thank you so much, McKenna. And being the Legal Awareness Week, I also hope to have more articles written to you in a language understood by members, published on your walls as you have always done. Also going on, have your final word. Ms. Eunice Lumalas, what do we anticipate? What is the future of ADR in Kenya, and what do we expect, especially from the legislative front?
Okay, thank you for the question. I was reading the East African Standard. I think that was on 30th of September, and it stated that in the risk and investment index, East African countries have actually gone down as viable investment destinations. Now this is bad because it spells, it's not very good for us as practitioners in this area, and they say the reason is the increase in conflict, politics, bad politics, and corruption. Now, where is the future of ADR, or how does this relate to ADR? Where I'm going to is that with the increase in legislation with respect to ADR, when you look at the Senate, we have the ADR bill, which is being sponsored by a very good friend of ours, Senator Kasanga, well done. And we also have the ADR policy being spearheaded by the NCIA. We have 2 mediation bills. And what I would like to see, I want to see us becoming courageous to find acceptable methods of managing conflict. We're talking about political conflict. The Constitution, Article 159. Article 159 Article 159 2C allows resolution of political disputes through ADR. We are seeing escalation of political temperatures. We want to see a proper panel, whether it's constituted by Kenyans or our friends regionally, being able to come in to help resolve political disputes, because that creates a good environment for us to undertake our international arbitrations, and we want that because international arbitrations mean Kenya as a destination for arbitration. Our taxi drivers are benefiting, our hotels are benefiting, like where we are today, and others. So we want to see political disputes being managed when they are still at infancy. So when we are doing our legislation, let's make provision for resolution of political disputes. Someone must go to the president who is at his level. Someone must go to other political players, bring them to a table and manage disputes before they escalate. And that has to go through wale wa Kenya wote ambao wanasikia, even in family disputes. We must be able to manage our disputes so that our children don't grow up believing that the best way to resolve a dispute is through fighting. There we are being socialized in a way to resort to conflict. And I think as a society we have to change the mind frame and learn to collaborate, because our constitution talks about collaboration all the time in the various institutions, even in intergovernmental disputes. That way we are able to move forward as a country quicker, resolve our disputes better. So I think in terms of what we want to see in legislation, we want to see proper framework for resolution of disputes that are political in nature. And then just to remind people that not all disputes can be resolved by ADR. Do not try to resolve sexual offenses, for example, by ADR. Okay, I have to mention that because of the increase of sexual offenses during this time for pandemic. So don't try, because I have also talked to the administration of justice. Some officers decide to resolve disputes at police stations that arise from sexual offenses like defilement and rape by ADR. That is not allowed by law. So you must be careful to find the appropriate method to resolve disputes. Finally, our courts, when you sit as a judge, you have to understand a matter and your law. We shouldn't have situations where, particularly, let me talk about arbitration. It's an international thing, and if Kenya is known to have courts supporting arbitration, we are bringing in proper investment. If you see London and what the London Court of International Arbitration has done in terms of income to London as a country, to the Great Britain, it's amazing. So that's what we hope the Nairobi Center for International Arbitration can be able to do for this country. And it can only do that if the environment, if the climate is conducive to that. So courts should be careful to understand that the disputes they are resolving are not just domestic, but everybody international is watching us. So let's be vigilant, but also let's embrace ADR. Thank you.
Thank you so much. Thank you so much. Senior Jackie Wahenya, what do you have to say? 2 recommendations in less than a minute.
Okay, I don't know whether that is possible. However, this is what I'll say. I think if I was to just say this one thing, it would be more than enough, because the truth is, ADR is the future. ADR has been growing at unprecedented rates in this country. I think the fastest growing profession in Kenya is that of mediators. I think in 2016 we had less than 60. I think now we are more than 500 and growing. So for the practitioners, first of all, I'll speak to our fellow members of the society. You are best placed, particularly the up-and-coming young advocates. This is a really good profession to go into. I know my chairman heads the WIBA committee, and of course that has been one of the areas we are saying, one of the most recent where the traditional practice areas have gone. If the cheese has moved, move with it. Right now, the best possible area that anybody could invest in for capacity building for themselves is the law society. From the law society is in ADR, mediation, also arbitration, and please look and see who can train you to get you to the best knowledge and capacity and ability. And then what is happening in addition to this is that as we are growing in capacity, we are also being looked at, not only in the region, but also internationally. And ADR is growing even across the globe. There are new conventions. There's a Singapore Convention on mediation, cross-border practice of mediation. The experts are here in this country. So this is my call, that as we develop, as we grow ourselves in the profession, also look outside the borders and see how we can impact the growth of ADR mechanisms around the world. Now, I've spoken to my fellow members in the Law Society, also those who may be watching us and they're from different professions. Particularly, specifically, mediation is open to all professionals. So long as they have a primary profession, they can also become mediators. They can train and they can be accredited by the judiciary, provided they fulfill the requirements and the qualifications of a mediator. So I think we can continue to watch this space. The constitutional foundation of ADR in our country has put us in an especially privileged position, which we should mine and we should make sure that we engage with and develop. Today morning, I listened to the first two panels, and they were speaking to traditionally constitutional area, discussions on the rule of law and also the access to justice. And consistently, there was this call for access to justice through alternative dispute resolution mechanisms. So I think the conversation is just going to become more wider, it's going to become more bolder, and for any practitioner today or any person interested in mediation, you have a role to play and a place for you within the ADR canvas.
Thank you so much, Senior Jacqueline Wihenya. And you touched something on training, and I believe that's one of the core mandates of the NCIA. So we want to ask her a question, Ms. Victoria. What do we expect in form of training that would better us attain our aspirations in regards to ADR in less than a minute?
Thank you so much for that question. I was actually waiting for it. So I think now the future of ADR in terms of training, we should make sure that ADR has 3 A's: accessible, available, and affordable. Now, as NCIA, we have recently launched our inaugural training in arbitration and mediation particularly. And we hope that in the future we'll be able to launch all trainings on all other aspects like conciliation, adjudication, etc. So our first training happened in September, Introduction to Arbitration. And we hope that in this month we'll do an introduction to mediation. And to note that because of this COVID pandemic, we've been able to have our trainings online. And that happened so successfully. So just to note, our training is not particularly just to the lawyers. Training is available for everyone, from beginners to experts, professionals. Anyone who needs training can come to NCIA. And all the informations about training, you can get them on our website, www.ncia.or.ke. And we hope to receive a lot of applicants on that aspect. Now, just to add one more thing on the future of ADR. We had mentioned previously about the independence of NCIA and the executive being involved. Just to note, we've had a few cases against the government actually, and in these cases the government has lost. So you can see that we are not having a favoritism kind of situation. We are having independent arbitrators overseeing these cases, and once the dispute has been resolved and there's an award issued, the government also complies. Now, another futuristic aspect in terms of the future of ADR. We have seen this pandemic. It has pushed us to rethink our ways of resolving disputes. Now, as NCIA, we have had cases coming in. They have not stopped despite the pandemic. And we've had to think, well, the cases cannot stagnate while we are saying, oh, well, there's pandemic, we need to adjourn these cases. So we have come up with our draft, actually come up with our virtual hearing rules. They'll be coming into force at the end of this month. But in the meanwhile, we've had our cases being had either fully virtual or hybrid system, whereby we can have one of the parties join in probably using Zoom, WebEx, Microsoft Teams, whichever system that is accessible to the parties. Despite this fact, we note that sometimes we have challenges in terms of the internet connectivity in Kenya, but we have really appreciated the fact that parties are able to acknowledge that there's a need to go virtual in terms of dispute resolution systems. So probably that's what I can say. And then also to note that NCIA has state-of-the-art e-hearing facilities. Any party can be able to use it. You don't have to have an arbitration clause with the NCIA to come and use our facilities at very affordable rates. We can have up to from 3,000 shillings a day to about 6,000 shillings a day, depending on the capacity of the participants. So personally, I can see there will be an upward trend. We are receiving a lot of cases as NCIA, and we are happy to promote the use of ADR in the aspect of uptake in Kenya. And so we are very delighted that we have been able to participate in this forum at LSK, and hoping that we'll be able to participate in more forums, and LSK will keep promoting the use of ADR and arbitration in Kenya.
Thank you so much. We hope that the LSK will do that. Lastly, Senior Njeri Karaoke. In 2 minutes, being our senior most, we would want to hear what would be your closing remarks insofar as ADR is concerned in Kenya. Thank you.
For the opportunity. Yeah, I know time is not. But I just want to emphasize the versatility of people in mediation, and pick up on what Jack earlier about the creative solutions that can come about through mediation, innovative ones as well, because what you're looking at is the interests of the parties. Mercy also spoke about a toolbox for lawyers. Let us look at this very, very seriously, because when a client comes to you, you're the advisor. Just because the client wants to go forward to litigation doesn't mean that you should do exactly that. Use the appropriate dispute resolution method or mechanism to resolve your client's disputes. So that behooves us as lawyers to improve our cross-border. Finally, no, not finally, because there's still 2 more. Keep in mind that since the mediation agreement that emanates from the mediation process is one that has been crafted by the parties, the concern that many parties have that somebody will renege from that agreement, I guess it has been done. If it has your input and you are happy with it or win-win, then what do you think you're going to have change on? Unless, of course, you've been dishonest, there's no goodwill in reaching that final solution, then there'll be a problem. Hence why conventions such as the Singapore Convention have come and enforced. In terms of enforcement, people are afraid, people are not going to stick to the terms of it. But the basic premise of mediation is goodwill. So if we are going to negotiate with good, then we shall come out with an agreement, and we shall maintain that agreement because we have agreed. To fall back on it, in terms of the bottlenecks mediation process, we have set it as an order of court. And as Mercy had said, or exactly it was Jackie who said that there are some areas where there's it can be left to the courts to make a decision on those points or points, can even refer it to arbitration. Okay? So not to look like you're boxing just because you're in court. It can be left to, especially when it's technical matters, can be left to arbitration. It can be forwarded to arbitration or left to the court to decide. Finally, in terms of arbitration, its efficiency cannot be it is efficient, provided that there's a goodwill and people want to resolve their dispute. Like, it defeats, I'm sorry, I look like I have frozen. I hope you've had me to the end. Thank you very much.
Once again, thank you so very much, Sina and Jerry Karaoke, and also to take this time to thank my panelists today. You have done extremely well, I must say. I have learned a thing or two, and now that we are getting down to this, I had begun on mediation, and after I've heard Senior Eunice speak so passionately about arbitration, I take it as a challenge. This should be my legal awareness challenge 2020. I hope to touch base 2021 on the legal awareness on the same. Thank you so very much again. All of them, Victoria Keegan, Jerry Karaoke, Matthew Nyambena, Masio Kiro, Caroline Kamenda, in as much as you were not able to attend, our Vice President, thank you so very much. Also, Ms. Jacqueline Roihenya, for taking your time to be here with us. I am sure you would have been in other places, but you took time to participate in the Legal Awareness Week 2020. We definitely want to see you again and again as we move this conversation further. Thank you so very much for making time for today. Friends, ladies and gentlemen, that brings an end to our day 2. And I want to welcome one of us, a good speaker, a good friend of mine, Ivan Sagada, to bring our day to a close and to also tell us about the day's activities tomorrow. Thank you so very much.
Good evening, ladies and gentlemen. I will keep it short. Thank you very much for those who have attended today. The day has come to an end. We want to thank the panelists. Nicholas, Jerry, Karaoke, Matthew Nyabena, Caroline Kamende, Okiro Makena, Jacqueline Roihenya, Chairman Nyabena in Mombasa. Tomorrow's activities start at 9 o'clock, where we'll have a panel dealing with children's rights from around 9 to 12 p.m. That should take us to the second panel that should be dealing with I don't see the second panel. We'll be dealing with what? We only have one panel tomorrow. So we only have one panel tomorrow dealing with children's rights. And we have the likes of the Honorable Billy Mabona, Emma Muma. He is a very difficult Polish name, Malinowski. We have Michael Wasonga, Evelyn Semba, Maureen Molime. Please stay tuned. We also have activities going on at Supreme Court and the Milimani grounds, also ones in Nairobi, and the various high court stations for Public Awareness Week. Members of the public, you are invited to join. Thank you very much. Adios. See you tomorrow. Thank you.
Seriously, where did you learn to do this work? This work? Moderating. Without planning, you know, he's done a good job.